This is NHTV2, North Haven Government Television, a service of North Haven Community Television. The following program is brought to you through the support of the Town of North Haven.
Okay, good evening, everyone. Welcome to a special meeting for the Planning and Zoning Commission of February meeting for an informative meeting from our town attorney to the commission. It is strictly really for the commission. However, it is an open meeting and anyone can join us. With that, let me introduce who I believe is here is Alan Fredrickson, our land use administrator. Andy Bellavacqua is our town engineer. I'm not sure if he's in tonight or not.
I don't think Andy felt there were any engineering issues to be debated this evening.
Okay, good enough. And we have Pam Miller, our clerk. And is Sonia with us tonight or not?
She is not.
Okay, and she isn't here. With that, if the commission would, if you want to call the roll, Teresa, Jennifer, I'm going to turn the meeting right over to you. And you can explain exactly what you're doing.
Sure, I'm happy to call the roll. Vern Carlson.
Aye.
Brian Cummings.
Here.
Teresa Ranciato-Vili.
Here.
Jim Giletti.
Here.
Rod Williams.
Here.
Mark Parisi.
Here.
And the record should reflect that Commissioners Richard Wilson and Paul Wyman are excused. Teresa, would you like to read the first item?
Jennifer, I didn't put it in front of me. I didn't know we
Okay.
were reading. I'm sorry.
That's fine. That's okay.
Thank you.
So we're on agenda item number 2, discussion of legislation on cannabis, accessory apartments, and parking with presentation by council. And I'm going to share my screen. Can everybody see the PowerPoint?
I can't.
Thank you.
I see it too.
If at any point you feel I'm not speaking loud enough, just please don't hesitate to interrupt me. As well, I know that we have Rod on with us tonight, and Rod obviously has some experience in these areas as well. So Rod, if you want to jump in at any time, please don't hesitate to do that. I'm happy to have you do that.
Okay.
So we're going to talk first about cannabis, and then I'll go in. So that's Public Act 21-1, and then I'll go into Public Act 21-29, which deals with the opt-out legislation for accessory apartments or accessory dwelling units and parking. And then I am going to talk to you a little bit, following that, I'm going to talk to you a bit about the status of the town's affordable housing plan that's due June 1st of this year. So just going into the Responsible and Equitable Regulation of Adult Use Cannabis Act, RERCA, is the acronym that's being used. So Governor Lamont signed the Public Act 21-1 into law on June 22nd of last year. The relevant sections for municipal officials, and I'm going to talk about the various sections in more detail a little bit later on, are sections 83, 84, 126, and 148. You received an email from me that has the entire Public Act available to you via link. It is 303 pages long. Quite a bit of it does deal with criminal related matters, and also with treatment related matters as well. And I'm not going to get into that tonight. I'm going to just really focus on those sections that I've indicated. So in terms of, just to give you an overview of the legislation, there are various points I think that are important to make. Again, in terms of changes in the law with regard to, and I'm just going to touch on possession and again, some criminal issues, just giving you the overview, but possession of specified amounts of cannabis among adults aged 21 and over is now legal. In terms of retail sales and cannabis revenue, retail sales of cannabis aim to begin in Connecticut in the second half of this year of 2022. The law does enact a tax rate structure on the retail sale of cannabis that includes a new source of revenue for municipalities. I'll talk about that in more detail in a little bit, but there's also the erasure of prior convictions that's covered under the law. So certain cannabis related convictions that occurred between January 1st of 2000 and October 1st of 2015 will be automatically erased. And then there's others that can be erased through a simple petition process. With regard to equity in the cannabis market, the law does create an equitable marketplace under which at least half of all initial licenses are reserved for social equity applicants, targeting those communities that have been most negatively impacted by the war on drugs. Equity in using the new revenue, the law directs that much of the new revenue from cannabis sales, an amount that's projected to reach approximately 40 million annually once the market is mature, for economic development in the cannabis industry and other industries. So, targeting again those communities that have been most negatively impacted. In terms of substance misuse programs, portions of the revenue obtained from retail sales of cannabis are to be directed to support substance misuse prevention, treatment, and recovery services. And then there are a number of other provisions in the law that make progress in other areas of enforcement having to do with safe driving, preventing underage use, advertising safe products, employment-related provisions, medical marijuana programs, so the palliative program, and prohibiting use of cannabis in state parks, state beaches, and on state waters. So in terms of regulation and regulation of use and so forth, DCP is the primary regulator and has control over the issuance of licenses and permits and also safety and the types of products available for sale. I did send to you, and I don't know whether you had an opportunity to look at it, but I did send you the proposed regulations that have been drafted by the Department of Consumer Protection. And that's an interesting read in terms of the various aspects of that. I may talk a little bit, depending on time, I may talk a little bit about some of the provisions of that. But I do encourage you, it is only 54 pages long as opposed to 303. So I do encourage you to read that because I think it's important to have some familiarity with many of the provisions that are contained in those draft regulations. So the Social Equity Council is a new state body. Again, the idea is for them to assist with social equity clients, and there's new programs to support social equity applicants. And then, of course, the regulation, in many of the webinars, they've talked about the partnership with municipalities. So municipalities dealing with the siting of establishments and also public consumption. Now, as far as the new cannabis establishments and licenses that are created by RORCA, so there were two prior licenses that were created by the Palliative Use Act, and that was the producer and dispensary license, as many of you are aware. There are 9 new licenses: cultivator, microcultivator, retailer, hybrid retailer, product manufacturer, food and beverage manufacturer, product packager, delivery service, and then transporter. And I don't know if there's interest in going through all of them. I do want to talk about some of them. So a cultivator, and this is on page 3 of the act. If you are on your computer, do you want to bring it up, please do so. But cultivator is defined at the beginning of the act as a person that is licensed to engage in the cultivation, growing, and propagation of the cannabis plant at an establishment with not less than 15,000 square feet of gross space. Delivery service is also defined on that same page, as is the dispensary facility. They're somewhat self-evident. And then food and beverage manufacturers defined on page 6 as a person that is licensed to own and operate a place of business that acquires cannabis and creates food and beverages. Hybrid retailer means a person that is licensed to purchase cannabis and sell cannabis and medical marijuana products. So again, that's combining both palliative use or medical marijuana and retail sale. So I was posed a question at one point whether or not those who are engaged in the sale of medical marijuana also have to sell recreational. They do not, but there is a hybrid retailer license. Micro cultivator means a person licensed to grow. This is on page 8. This is definition number 36. Micro cultivator is means a person licensed to engage in the cultivation, growing, and propagation of the cannabis plant at an establishment containing not less than 2,000 square feet and not more than 10,000 square feet of gross space. So you see the difference between cultivator and micro cultivator prior to any expansion authorized by the commissioner. And then finally, I'm not going to go through again all of them, but retailer means a person excluding a dispensary facility and hybrid retailer that is licensed to purchase cannabis from producers, cultivators, micro cultivators, product manufacturers, and food and beverage manufacturers, and to sell cannabis to consumers and research programs. In terms of steps in licensing, our next slide. So applications are accepted for a lottery, and then the lottery winners are selected. There's a review by DCP and/or SCC of lottery winners, and then a provisional license is provided. For the next 14 months after the provisional license is provided, the applicant secures siting, initiates construction, etc. And then there's a final license review by DCP. In terms of the market timeline, applications open, so lottery applications opened in the fall of 2020. And in the winter of 2021 to 2022, lottery applications continued to be accepted. There was provisional license review that's already started. And some SE cultivators licenses have been awarded in the spring of this year. There's going to be a continuation of provisional license review and approval. What they're doing is they're staggering by credential, and there's going to be the issuance this spring of provisional licenses. And in the summer, it's expected that again, that provisional license review and approval will continue on a staggered basis, with final licenses beginning to issue over the summer and businesses ramping up. And they expect that by this fall that they'll be issuing final licenses and there'll be market openings. So in terms of any cap on licenses, there is no global cap on the number of specific license type, But until June 24th of 2024, there's a cap of one license per 25,000 residents for retailers and micro cultivators in each town. So that's important. I know there's been a lot of news given to that issue as well. So the cap applies separately. Again, so that's one license per 25,000 residents for retailers, separate from one license per 25,000 residents for micro cultivators. So, and it is rounded up as well. So I want to turn next to actually reviewing the various provisions.
Now, let me just ask a quick question. When you say it's rounded up, does that mean for our town, so since we're under 25,000, it would be one of each?
Yes, yes, exactly. One of each. Thank you for that question. It's an important point. So in terms of section 83, we're going to look at that first. So section 83 and 84 of the Act impact municipalities and address municipalities' ability to regulate cannabis. Section 126 governs the taxation of cannabis, and then section 148 addresses the municipality's zoning regulations related to cannabis. So if you look at the text of section 83, again, if you have the regs or not the regs, the act in front of you, if you look at section 83, which was effective July 1st of 2021, it says the following. Upon, and I'm going to kind of go through this somewhat methodically, upon the petition of not less than 10% of electors of any municipality lodged with the town clerk at least 60 days before the date of any regular election, as defined in section 9-1 of the general statutes, the selectmen of the municipality shall warn the electors of such municipality that at such regular election, and this is kind of, I think, the important part, a vote shall be taken to determine, 1, whether or not the recreational sale of marijuana shall be permitted in such municipality, or 2, whether the sale of marijuana shall be permitted in such municipality in one or more of the classes of licenses of cannabis establishments. The ballot label designations in a vote upon the question of cannabis establishment license shall be, shall the sale of recreational marijuana be allowed in, and then insert the name of municipality, or shall the sale of cannabis under, and you specify the license or licenses, be allowed in, and then name of municipality, or shall the sale of recreational marijuana be prohibited, no licenses in, and then name the municipality, and shall be provided in accordance with the provision of section 9-250 of the general statutes. No elector shall vote for more than one designation. Such vote shall be taken in the manner prescribed in section 9-369 of the general statutes and shall become effective on the first Monday of the month next succeeding such election and shall remain in force until a new vote is taken, provided such vote may be taken at a special election called for the purpose in conformity with the provisions of section 9-164 of the general statutes, and provided at least 1 year shall have elapsed since the previous vote was taken. The provisions of chapter 145 of the general statutes concerning absentee voting at referenda shall apply to all votes taken upon the question of cannabis establishment license. Any class of cannabis establishments already allowed in a municipality shall not be affected by any vote. So there's a lot there. So let's break it down. So this, again, this is, I'm sorry if I didn't say this at the beginning, this is subsection A of that section 83. So the comments from OPM and or OLR are that a municipality must hold a referendum on whether to allow certain cannabis sales if at least 10% of its electors petition for such a vote at least 60 days before a regular election. So again, specifically these votes may determine whether to allow, 1, the sale of adult use marijuana in the municipality, or 2, the sale of adult use marijuana in one or more of the cannabis establishment license types. And I'm not going to go through the designations again. I've read those to you. So the referendum and ballot designations, they conform to existing procedures. As it states, the results take effect on the first Monday of the month after the election and stay in effect until another vote is taken. And it does allow a vote to occur at a special election following existing procedures if at least 1 year has passed since the previous vote. So that's a question that's come up a lot, whether, regular elections versus special election. So it does allow it to occur at a special election. Existing laws on absentee voting at referenda apply to these votes. These referenda do not affect any class of cannabis establishments, as I stated at the end of the provision when I recited the language. It doesn't affect existing cannabis establishments already allowed in the municipality, and it does not affect any class of cannabis establishments that do not sell adult use cannabis, including a medical dispensary and establishments that grow cannabis products. So your producer and your dispensary. And then the next provision, which is subsection B, indicates that no municipality shall prohibit delivery of cannabis to a consumer, qualifying patient, excuse me, I should have turned that off. Qualifying patient or caregiver when the delivery is made by a retailer, hybrid retailer, dispensary facility, delivery service, microcultivator, or other person authorized to make such delivery pursuant to REVARCA. No municipality shall prohibit the transport of cannabis to, from, or through such municipality by any person licensed or registered pursuant to the act to transport cannabis. I'm going to stop saying the acronym because it's awkward. Now on that analysis from OPM and ORLR with regard to this subsection, municipalities cannot prohibit the delivery of cannabis to consumers or qualifying medical marijuana patients or their caregivers if the delivery is made by someone authorized to do so under the bill. So for example, it lists, a delivery service, microcultivator and the like. It also bars municipalities from prohibiting the transport of cannabis to, from, and through the municipality by anyone licensed or registered to do so. Subsection 3 states that no municipality or local official shall condition any official action or accept any donation in monies or kind from any cannabis establishment or from an individual or corporation that has applied for a license to open or operate a cannabis establishment in such municipality. So no municipality shall negotiate or enter into a local host agreement with a cannabis establishment or a person that has applied for a license to open or operate a cannabis establishment in such municipality. So there's a ban on certain actions and local host agreements. Municipalities and local officials are prohibited from conditioning any official action on or accepting any donations from any cannabis establishment or applicants for cannabis establishment licenses in the municipality. And there's a bar from negotiating or entering into any local host agreement with a cannabis establishment or licensed applicant. Subsection D states the following, and this is the last section in last subsection in section 83. For up to 30 days after the opening of a retailer or hybrid retailer, a municipality may charge such retailer or hybrid retailer for any necessary and reasonable costs incurred by the municipality for provision of public safety services in relation to such opening, including but not limited to public safety costs incurred to direct traffic, and that's not to exceed $50,000. So the bill allows municipalities, or the law allows municipalities for the first 30 days after cannabis retailers or hybrid retailers open to charge them up to $50,000 for any necessary and reasonable municipal costs for public safety services related to the opening, such as for directing traffic. Section 84. Subsection H of subdivision 7 of subsection C of section 7-148. Okay, this is a statutory section that pertains to the scope of municipal powers, the Municipal Powers Act. Okay. Is repealed and the following is substituted in lieu thereof. And this was effective October 1st of 2021. And here's the text. It says that municipalities may regulate on any property owned by or under the control of the municipality any activity deemed to be deleterious to public health, including burning of a lighted cigarette, cigar, pipe, or similar device, whether containing wholly or in part tobacco or cannabis as defined in section 1 of this act, and the use or consumption of cannabis, including but not limited to electronic cannabis delivery systems as defined in section 19A-342A, or vapor products as defined in said section containing cannabis. If the municipality's population is greater than 50,000, such regulation shall designate a place in the municipality in which public consumption of cannabis is permitted. Such regulations may prohibit the smoking of cannabis and the use of electronic cannabis delivery systems and vapor products containing cannabis in the outdoor sections of a restaurant. Such regulations may prescribe penalties for the violation of such regulations, provided such fine does not exceed $50 for a violation of such regulations regarding consumption by an individual, or a fine in excess of $1,000 to any business for a violation of such regulation. So the prior subsection, what it stated is that municipalities could regulate on any property owned by the municipality, any activity deemed to be deleterious to public health, including the lighting or carrying of a lighted cigarette, cigar, pipe, or similar device. So now it's, covering, obviously, not just tobacco, but cannabis, as well as covering all the cannabis delivery systems and the vapor products as well. So that language has been changed pretty extensively. I'm not going to get into, there was some controversy with regard to this section, and what ultimately happened was there was an interpretation given that existing law, this is going, because again, I said that this particular section was effective October 1st of 2021. There was some controversy about the language, because when the act was revised for the last time, the dates were all changed accordingly. They had pushed up the effective date of the act, and all the subsequent dates were not addressed, and so there was some concern about people being able to smoke in public, and there was an interpretation that was given by the state that existing law allowed municipalities to regulate any property owned by or under the control of the municipality. So, but we've moved on from that because we've now passed the effective date of that section. So again, existing law does allow municipalities to regulate activities deemed harmful to public health, including tobacco smoking on municipally owned property, but the bill broadened this to include property that a municipality controls but does not own. For the purposes of this section, property that a municipality controls includes but is not limited to sidewalks, parks, beaches, municipal land, and buildings. It specifies, the act specifies that this regulatory authority applies to smoked or vape tobacco or cannabis and other types of cannabis use or consumption. So municipalities are permitted to ban cannabis smoking and vaping at outdoor sections of restaurants, and through regulations, they can set fines for violations, again, up to $1,000 for businesses who allow cannabis smoking or vaping contrary to the regulation of the municipality. So With regard, I am going to, I know there's interest in, what is the municipal sales tax piece? What are the components of that? I'm not going to go through the text of that. It is lengthy. So I'm going to skip that, but I'm going to give you some of the analysis that's been provided by OPM and OLR. This legislation, so this again is section 126. It's one of the sections that was effective July 1st of last year. It imposes a 3% municipal sales tax on the sale of cannabis that applies in addition to the state's 6.35% sales tax and the state cannabis tax established under the act. It specifies the purposes for which municipalities may use the tax revenue. And the 3% municipal sales tax, I hope you guys can't see that. I don't know what's going on. It's again specifies the purposes for it to use the tax revenue, and it's administered through DRS, so the Department of Revenue Services, though each municipality will be responsible for collecting the appropriate amounts as identified by DRS. And there's a municipal designee provision. So the act requires that each municipality in which a cannabis retailer, hybrid retailer, or micro cultivator is located submit to the DRS commissioner at least annually the name and contact information of the individual designated by the municipality to receive notifications regarding the tax. The DRS commissioner has to notify these designated individuals of the tax amount reported due from each cannabis retailer, hybrid retailer, and micro cultivator located in their respective communities. So such municipalities are then responsible for collecting the tax payments from each payor. So that's how it works. In terms of the municipal use of funds, the amounts remitted become part of municipalities' general revenue. Okay, so they're going into general revenue, and they may only be used for the following purposes. Number one, streetscape improvements and other neighborhood developments in communities where cannabis retailers, hybrid retailers, or micro cultivators are located. Two, education programs or youth employment and training programs in the municipality. Number three, services for individuals living in the municipality who were released from Department of Corrections, custody, probation, or parole. Number four, for mental health or addiction services. Number five, for youth service bureaus and municipal juvenile review boards. And number six, community civic engagement efforts. So those are the particulars of that section. Again, I know there's interest in that, of having an understanding of how that works. That is, again, section 126 and some of the particulars with regard to it. Finally, section 148, also effective July 1st of 2021, says it gives a definition of municipality in subsection A, and then it says, and this is the right, this is the piece that touches on the municipality zoning regs and local ordinance. It says in subsection B, it says any municipality may by amendment to such municipality zoning regulations or by local ordinance prohibit the establishment of a cannabis establishment, establish reasonable restrictions regarding the hours and signage within the limits of such municipality, or establish restrictions on the proximity of cannabis establishments to any of the establishments listed in subsection A of subdivision 1 of section 30-46 of the general statutes. The chief zoning official of a municipality shall report in writing any zoning changes adopted by the municipality regarding cannabis establishments pursuant to this subsection to the Secretary of the Office of Policy and Management, so to OPM, and to the department not later than 14 days after the adoption of such changes. So you pass a reg, you're reporting it. Unless otherwise provided for by a municipality, this is subsection C, through its zoning regulations or ordinances, a cannabis establishment shall be zoned as if for any other similar use other than a cannabis establishment would be zoned. D, any restriction regarding hours, zoning, and signage of a cannabis establishment adopted by a municipality shall not apply to an existing cannabis establishment located in such municipality if such cannabis establishment does not convert to a different license type for a period of 5 years after the adoption of such prohibition or restriction. E, until June 30th, 2024, this is one of the magic dates in the legislation, no municipality shall grant zoning approval for more retailers or micro cultivators than a number that would allow for one retailer and one micro cultivator for every 25,000 residents of such municipality as determined by the most recent decennial census. F, on and after July 1st, 2024, the Commissioner of Consumer Protection may, in the discretion of the Commissioner, post on the Department of Consumer Protection's internet website a specific number of residents such that no municipality shall grant zoning approval for more retailers or micro cultivators than will result in one retailer and one micro cultivator for every such specific number of residents as determined by the Commissioner. Any such determination shall be made to ensure reasonable access to cannabis consumers. So on or after July 1st, 2024, the Commissioner of the Department of Consumer Protection is going to decide whether that 25,000 resident figure changes. Okay, so that's kind of important as well, just to point that out. For purposes, and this is subsection G, for purposes of ensuring compliance with this section, a special permit or other affirmative approval shall be required for any retailer or micro cultivator seeking to be located within a municipality. A municipality shall not grant such special permit or approval for any retailer or micro cultivator applying for such special permit or approval if that will result in an amount that number one, until June 30th, 2024, exceeds the density cap of one retailer and one micro cultivator for every 25,000 residents, and two, on and after July 1st, 2024, exceeds any density cap determined by the Commissioner under subsection F of this section. So when awarding final licenses for a retailer or micro cultivator, the Department of Consumer Protection may assume that if an applicant for such final license has obtained zoning approval, the approval of a final license for such applicant shall not result in a violation of this section or any other municipal restrictions on the number or density of cannabis establishments. So they're looking to the towns to make sure, you know, that they're getting it right in terms of the zoning approval that's being given, so as not to violate that density cap. So again, there's a lot here. I think that you know, again, I'm going to kind of just revisit that. So it's authorizing municipalities to enact certain zoning regulations or ordinances for cannabis establishments. It's temporarily prohibiting municipalities from granting zoning approval for more retailers or micro cultivators than the number that would allow for one of each for every 25,000 residents. And then it allows the DCP Commissioner to set a population-based cap for the number of retailers and micro cultivators in the future. So again, that date is on or after July 1st of 2024 that the Commissioner is going to decide that. In terms of your general zoning authority and restrictions on that, it allows municipalities to amend zoning regulations or local ordinances to take certain actions regarding the cannabis establishments. You can prohibit them from opening. You can reasonably restrict their hours and signage, or you could restrict their proximity to religious institutions, schools, charitable institutions, hospitals, veterans homes, and certain military establishments. That's what that section that was making reference to earlier.
Jennifer,
then,
can I,
yes, Yeah.
I just have a question, in
Yes.
relation to what you're just talking about.
Mhm.
So could our board possibly, take the restrictions or the permitting we have in place now for liquor stores and use that, make it similar, if not the same, for cannabis?
And I am seeing some of that. I was going to talk a little bit. I do have, our office has been keeping a spreadsheet as, we learn about other municipalities and what action they're taking in response to the law. There are some communities that are heading sort of down that path of doing something similar to what is in place for liquor. Yes.
Jennifer, just piggybacking onto that, there was a reference to Section 8 something or other that a town could institute some of those particular proximity requirements.
Yes.
I haven't checked that. What are those? Are those similar to the liquor regulations?
Yeah, I'm gonna pull that. I could pull that up for you. Just give me 1 sec.
When you read it, it sounded like that was the case.
Ellen, I think it's also things like churches and other
Yes, schools.
schools, right?
Those are all the things that we have in the liquor reg. Yeah. Okay.
For Jennifer, this is Brian. For Jennifer too, well, you're looking for that. The question, does that apply to hybrid stores, medical stores, or just for the retail stores as far as comparing it to liquor stores in that avenue? Because that's a real good question to, if you're gonna break them down into different stores, so to speak.
So you can restrict again, in terms of the types of cannabis establishments, you don't have to permit all the types of establishments. You can pick and choose in terms of what you allow, and so you would be able to restrict. Yeah. Just give me 1 sec. Just want to pull up. It's actually. Why is it citing to? It's 30-46. Give me 1 sec. So yeah, so it's citing to 30-46. So proximity of permit premises will have detrimental effect on any church, public, parochial, school, convent, charitable institution, hospital, veterans home, any camp, barracks, flying field of armed forces. So this is what it's making reference to, is 30-46 as far as the location.
Okay, thank you.
Yes. So I'm not quite sure why all of a sudden I'm getting a little reverberation. Just going back. So with regard to next steps, as I indicated, there are some communities that have acted in response to the passage of the Public Act. There are a number that have established prohibitions. There are a number that have okayed retail sales in certain areas of town. There are some that have put even have allowed the location of retail sales in certain areas and then put a cap on the number as well. Some have just outright banned sales alone. There have been some towns that have only acted to ban smoking on town properties and outdoor restaurants. They're by far, though, the largest number are the towns that have entered a moratorium to study the issue. And the moratoria range from anywhere from 6 months to, I saw one town that has one in place for 18 months. You know, that's not something that I would recommend. I think that is an awfully, Rod, I don't know if you want to weigh in on that. I think that's an awfully long time to enter a moratorium. Because, you know, I mean, if you're going to enter a moratorium, you should be actively considering the issue. And you should be able to determine in a lesser period of time, I think, what you want to do on the matter. So, you know, I don't, you know, it's a lot to digest. I said to you, you know, I gave you the regs too to look at. I think the regs are very important to look at because it talks about such things as, you know, minimum security procedures, and you know, the furnishing of information and records by the cannabis establishments, and just operational issues as well. So it's an important thing, I think, to take a look at. You know, I have a lot of information. When palliative use was passed, I had been monitoring that as it went through the hearing process. I have a lot of information that I can share with you, you know, whatever you're interested in. Again, you know, we've kept a log on what the other municipalities in the state are doing. So I have, you know, quite a bit of information on with regard to draft language and so forth as well. So I'm happy, you know, to share whatever information you'd like me to share with you. It's a lot to digest, and I think you gotta, you know, you gotta go through it and you gotta consider what direction you want to go in on it.
Jennifer, it's Vern. You just simply because they took a prolonged time, put a moratorium on for a prolonged period of time, doesn't mean that they can't act on it much sooner.
No, that's true. Sure. Yeah, sure. If the decision is reached, like I mentioned, the one town that is taking 18 months, if a decision is reached within 6 months or 9 months, yeah, that they don't have to take that entire time, certainly. But you know, Rod and I had a conversation about this. I mean, my thing about the moratorium, I think the best use of that time, if that's something that the commission is leaning towards, is, you know, you want to sort of actively have a discussion at your monthly meetings with regard to the matter. I think you would want to invite, you know, whether it's, you know, certain departments of the town in to weigh in on particular potential uses. You could invite, I mean, you've received, the town of North Haven, like all the towns throughout the state has received a number of inquiries from producers, from cultivators, from retail sale folks, you know, who, you know, because there are a number of folks who are interested, obviously, in establishing a business in the various communities. And I think you could have, you know, you could have an evening where you have a meeting and you invite some of the folks that have inquired what North Haven's position is on the matter and invite them in to talk about their business. Because I think that that's one way that you could learn about the particulars, is to have that dialogue with the folks who are engaged in the business, and that, they have other establishments. I believe you received some inquiries from some businesses in Massachusetts that are looking to expand to Connecticut. That's one route that you can go.
Yeah, my
In terms
understanding,
of making use of that time, I think it would be a good use of that time. If you're going to do a
Let me
moratorium.
put me in here a little bit. I mean, because you're presuming that we're going to do a moratorium, and I'm not in favor of doing a moratorium at all. Just as, like always, one vote and one voice, because I don't know what we're going to accomplish with the moratorium. And so, but look, let me ask you a couple of things, because there was a lot of information here. One of the things that you said was there could be a referendum not to have any establishments at all, but somebody has to affirmatively bring an appeal or whatever, get 10% of the voters in town or electors in town to do that. Is that correct? Absent that, our regulations would control what they can or cannot do. Is that accurate?
Yes, that is accurate.
Okay, so, and we don't know at this point. I mean, we have some reason to believe that somebody will bring such a petition to town to not allow any facilities. And could they ban every type of facility? Could that be every kind would be banned if that's were to carry the day in a referendum?
By the language that's in the statute, yes,
Okay.
that
And
appears to be the case.
if
And I have not heard of anybody interested in doing that. In terms of the inquiries for the town of North Haven, that I've been aware of, because some people have reached out to me, as counsel. The inquiries that I've seen have been for retail sales.
yeah, and that's
So
what
that's all I've seen. Yeah.
the most active sector would be to go and sell it. And if I understood what you were saying, is the act kind of establishes the right to have like an Uber Eats of marijuana, if I'm understanding it. It's like we couldn't ban people from getting deliveries of marijuana, even if we didn't have shops. Is that right?
We couldn't ban people from receiving deliveries.
Because I thought it said they couldn't stop people from delivering as long as it was legal to deliver.
That's what I heard as well.
That's 84C or one of those
Yeah.
early ones we were looking at.
So, I mean, it sounded to be like
Yeah.
Uber Eats of marijuana. It's like, okay, even if we don't have the store, people could call up and get it delivered. That's what I got. And I know this is very much a gloss, and there's so much going on here. But that's what it sounded like to me. But I mean, it's so hard because there's so many parts to it. I didn't even consider all the cultivators and people growing it and that whole thing. I was kind of more about the shops. And my leaning about the shops is that we treat it like liquor. Listen, if it's whether you like marijuana, don't like it, or whatever, the legislature has made it legal. If it's legal, like everything else, let's get the revenue out of it. And I don't know why we would stop businesses, but I could understand other people having different opinions. And I can understand people in town coming forward with a different opinion. I don't know how and I think it makes sense to solicit information from people in town, but God knows we don't, not that I don't want to listen to it. I just don't want to listen to it for 8 hours some night. But we should somehow get some input from the town, I think, right?
That's
Anyway.
what I thought.
So the question
Yeah.
becomes, in what context do you do that, right?
I know.
And I didn't assume at all that you were going to do a moratorium. I'm just telling you that the vast majority of the towns, that's what they did.
No, I got that.
Tons of towns, yeah.
There was an article in the Register to that effect, that 40% of the towns had already enacted either moratoriums or prohibitions. I didn't read the article, but it said 40% were putting the brakes on already, which is interesting considering the legislature passed the thing. So interesting, but whatever. It seems to be, unless I'm missing it, the thing that we've got to decide most currently is if we're gonna put the brakes on it, then decide to do that. If you can have a moratorium, then decide it. If you're not, then we got to start worrying about what our regular, because you had said this before. If somebody came to us right now and said they want to put a dispensary, or on Washington Avenue, wherever, what would happen? Do our current regulations apply and say it doesn't say anything about marijuana? Is that what would occur?
Yeah,
We
we would take the position that the use is not permitted.
Not permitted, right, anywhere. So we have to come to some sort of conclusion at some point of what we're gonna allow, and where we're gonna allow, right?
Yes, yes.
Jennifer, this is Brian, just so I understand this. As far as petitioning, any resident can get the signatures necessary for a petition as specified by how many days before election and what you said there. So that any
Yes.
resident can do that. This was not led or just given to the Board of Selectmen to do. The electors of the town can actually do this.
Yes.
Thanks.
So Jennifer, question, as far as informational, could we decide to ask the the selectmen to have an informational town meeting to just hear what people think?
You could do that, and in many towns, the legislative body and the Planning and Zoning Commission, no pun intended, but have held joint meetings to get, so that the Planning and Zoning Commission too is getting feedback from the legislative body. I've seen that in a number of the minutes that I've looked at, where there is a Board of Selectmen, where there is a town council, there has been a combined meeting with Planning and Zoning, because Planning and Zoning has been interested in hearing what the legislative body has to say with regard to it. So that's one thing that you can do, or you can, you could ask the Board of Selectmen, I guess to hold a meeting to discuss the topic as well at their level, right?
Yeah, I mean, so
certainly
we could
do that.
request to hold a public meeting to listen to the public.
So is there a time frame that we have to enact some sort of regulation, even if it's a prohibition, that we have to do? If we just did nothing, and it's
Yeah.
not
And-
voted down,
And some towns are choosing to do nothing. I see, I have a more offense minded outlook on things. I think you would be better off, I just think, figure it out, figure out what you want to do, put the regulations in place, have it be what you want it to be. I mean, that's, as your counsel, I'm much more in favor of that than doing a wait and see. Roll up your sleeves and figure out what makes sense in terms of getting the right regulations in place. So that way you're not deciding like, say somebody comes before you with an application and it's for one of the uses that you're all in agreement. Yeah, we should let's allow it. We feel comfortable with it. But within the confines, when you're talking about receipt of an application, you have the confines of a timetable, a statutory timetable. And I think you're much better off if, you figure out what you want the regs to be, as opposed to, getting an application and have it be what the applicant wants to be, and maybe not having the time to sort of turn it over the way that you want. And I mean, look, that's not to say you can't, if something happens and you're in a circumstance where something needs to be addressed about the particular business or whatever, that you can't change your reg or amend it, whatever. But I just think it's a better way of doing it. And I think that that's why you are seeing so many moratoria.
yeah, but I completely agree with that. But what I'm saying to you though is, like, if somebody came with an application tomorrow or next month, I don't know how we could approve it if it's not a permitted use in any of our districts. Unless.
I do agree with that, but
when the regulations change in accordance with their application, that we would then have to vote on. And rather than, and I understand completely, I'm just asking, in the act, does it say we have to figure out some regulations or prohibitions or anything in a given period of time?
It does not say that, no.
Interesting.
And
Okay.
there are some communities that, that's the decision that they have made is a wait and see decision. They're choosing not to take any action at this time.
Yeah, no, I completely.
And it's been conscious.
Regulations.
That's pretty well, I'll tell you that.
You what?
Jim, I think that's really leaving yourself open for anything to be brought in, and then you must act upon it.
No, it's not though. I mean, that's my point, because it's just not allowed right now.
No.
So how is it leaving itself open? So, but whatever. We
Not-
can argue with that. I think for sure we need to come up with regulations. I'm not debating.
Gotta do something, I believe, anyway.
Well, I agree. It was just kind of it's the time frame issue. Okay. Interesting mess.
It is an interesting mess, and it is.
I have
think we
kind of a
really-
question. I'm sorry, Vernon. I just have a question to throw out there to the commission. Teresa has mentioned specifically getting public input on this. And I've thought about it a little bit. And I have absolutely no idea what way the public would go on it. That seems to me to be a valuable piece. Is there any thought to requesting a referendum on it? An actual vote?
I'm not in favor of a referendum on it.
Okay,
I mean, I'm not, that's just me.
fair enough.
Well, everyone else could weigh in. Quiet people.
I agree
Wow.
with that.
Also, so Jennifer, I know you're thinking about a moratorium on it for a while. Now, how long were you thinking?
I mean, again, that's entirely up to you. In terms of the period of time, you can make it as short or as long as you think you might need to have, some meetings to get the information that you desire to receive
Well,
to help to inform you. So I would say that, you can go as short as 3 months. There are many towns that have done 6, 9 a year. Again, the longest that I saw was the 18. But there are many towns that have done 6 months.
yeah. Well, in any event, I think you
I
need
mean,
some
you're
time.
heading, you're heading into the summer months, so soon enough. So,
You really need to- you really need to
think
see
about,
what-
do you want something in place before summer? I mean, then you go with a shorter period of time. It's gonna take a little bit of time to draft what you
It is
want.
gonna take some
so-
time to draft it out, but Jennifer, it's the idea is you want to get some information from perhaps surrounding towns, just more suburban towns. Well, I guess North Haven's not quite so suburban as it used to be, but in any event, take a look at some towns of comparable size to North Haven and how they have handled it. Just to get some input, perhaps you get something good. If not, you just disregard it. But by all means, we got to look somewhere.
So if there are particular towns that you're interested in, I can tell you whether or not they've acted, but
This may have no bearing on anything because New Haven is not comparable in size, but I just wanted to share with everyone that today, maybe tomorrow, New Haven's ordinance is going to get a draft that I was involved in working on is going to get submitted to the Board of Alders to work its way through the New Haven legislative process to regulate it. And so I spent a fair amount of time with that and understand what they're trying to do. Just one of the things that the ordinance as it is now will do is not allow retailers or I think micro cultivators in any residential zone. Actually, I think any establishment is not allowed in a residential zone. Obviously, you have to allow transporters and delivery services to deliver to residences, but the operations aren't allowed to be located there. And then they have to apply for a special permit with certain criteria above and beyond what the regular special permit criteria are to, you know, to gain a permit to operate in the zones where it is going to be permitted, which are generally business and industrial zones.
Well, business and industrial, yeah, I guess that's what we'd be looking at the same thing here, you know, because you take all along Washington Avenue. That's certainly business on both sides of the street, up and down the avenue, just whereabouts that it may or may not fit in, or I don't know, but certainly somebody would target that right off.
So Vern, that was sort of my reason to say if we look at our liquor permits, I mean, we know where liquor stores are and are not allowed.
Right, I understand. I understand exactly. I thought about that plenty, Teresa. But I didn't want to just stop at, you know, target the liquor stores and use that as, you know, as that there was also talk about just going to your local drugstore, for God's sakes, and with a prescription and a prescription, see if they handle it there. There was talk about that as well. But I mean,
But you have to remember, you can, based on what Jennifer told us, you can only have one of these dispensaries.
right, yeah, I know.
Retailers.
Only, yeah, one of these.
All the way to Washington Avenue.
That's the whole thing, Jim, is that it's one of each, and do they have to be together?
Yeah,
Now,
no, we don't have to do both. But just going back, hey, Rod, out of curiosity, I mean, can you share your draft at some point? Because I'd be interested to see what New Haven's proposing to do. I know
Yeah,
it's
I'd be happy. I think I can. I don't see why I wouldn't.
so, I mean, you have a lot more people, so you could have more establishments set up, but I'd still be interested to see what they considered.
But listen, I think another thing to remember though is, yeah, that there can be 5 in New Haven, but it looks like the way this is drafted now, the public, whatever, RERACA Act, it anticipates that there could be more in the future. And so we need to just think about that. If there are going to be more, one of the other things that New Haven does is it prohibits any one retail establishment from opening up within 1,500 feet of any other one, so that you don't get these clusters essentially. So if maybe North Haven will never have an overwhelming amount of them, but it's just something to think about. That there might be
Liquor permits or liquor regulations do that. You can't have them.
right.
Yeah, exactly. Sure.
Jennifer, or
Yes, sir.
Rod, or somebody, in respect to that, there could be a change put in this, from what I got of what you were saying. There could be a change. It could be the 2 for North Haven at this point, but it could be changed down the road a ways. Now, could that be changed up or down, or just up?
Well,
I
it
don't know
does.
that you can go back.
Yeah, I don't anticipate it's gonna go down, right, Rod? I mean, I would think
Right.
that they would allow more rather than fewer, but
Yeah, well, that's what I heard Rob say. Rod, you said you anticipated going up. Is that what you're
Yeah, I
saying?
mean, I think it would be a problem if you started taking
I
away.
know, take it away, of
Yeah.
course, but, you know,
Yeah.
this is terribly expensive to get into, I believe.
it's-
Right.
This is, anybody can go. Although, to be honest with you, I did hear of some stories of New York City where they come in and set up shop on the corner and they're selling whatever they want to sell. I don't know if that's true or not, but I did hear that.
Absolutely true. There are trucks on the streets in New York City. that
Yeah,
sell-
I heard something like that, Jim, and
I saw some of our board.
I found it hard to believe, but it is something like that, yeah.
Oh, there definitely are trucks in Times Square.
Someone came into New Haven's planning and zoning office at one point and tried to get permission to essentially open up a trade show, a cannabis trade show, and told them that he's been doing that in Hamden for some time now, a number of events. And I read something about something that may or may not have happened in Hamden where there was something like that, and that they had to take some acts to prevent it, I guess.
No, that is absolutely true. That from what I saw on TV and what I did hear, that there was in Hamden, and there was so much commotion where they had to move to a more, I guess, off of Treadwell, in fact, of a Treadwell Street in Hamden,
Right.
where they're operating now, I believe. I've never been there. I've never seen it. I've just heard about it, but I heard it's like a carnival almost. But
Maybe it's like
Yeah.
a Grateful Dead concert.
Well, it kind of actually reminded me of that. I drove by it once. We were going to drop off something in the storage unit. I thought, what is going on here? There were a lot of people walking up and down the street. And I couldn't figure out what it was because there's no establishment there. And there were hundreds of people walking around on the
right,
street.
I
Yeah.
wasn't there.
The way I understood it, was because they couldn't sell it, they theoretically give it away and then you make a donation. So that's how they were getting, that's what I read. I don't know if that's.
no,
Yeah.
that's
Actually,
exactly right.
I did see that, Jim, up in Maine before it was legal. That's exactly what they were doing. There was like a little craft fair and they were doing exactly that.
So how do we get off the dime here? So we can go to the next thing, or what are we doing?
I don't know. We got to look into something for sure.
Okay, that's
Brian, I think the idea of public input was a really good idea by Teresa, and having people come out and speak, and also getting the other departments involved throughout the town, whether law enforcement and also Board of Ed, and see what they all think about it to help us out here, because we do represent the whole town. And there are a lot of issues. I saw the mayor of Hamden on the TV talking about that place they were selling over there. And she's kind of got a backstepping now and trying to figure out what to do and to get things in place to take care of a problem that's come up. And I hope we can be ahead of the curve on that. So what it takes to do that, I guess we all have to come up and figure that out. But number one is public input, I believe. Thanks.
all right. Okay. So, okay. All right, so I'll buy that. So what do we do now?
Let me, if we're gonna try to do that, then doesn't it make sense to maybe, and while I don't like the idea of a moratorium, do a 2 or 3 month moratorium so we have time to get the public, or do we just not, I mean, if we don't do anything, I mean, I guess I think maybe a 3 month moratorium would be okay if we want to get public input and set that up via the town meeting or however we're going to do it. I don't know. What do you guys think?
Teresa, if we're going to do a moratorium, if we were going to do that, instead of saying, we can always move it up to 3 months. We can always act on it anytime. If we took a 6-month moratorium, give us an idea. If we come up with what we want to do in 2 months, we just act. It's not.
I don't like a 6-month moratorium, Vern, because it looks like we're punting, and it also looks like we're gonna wait. I don't think we need to wait and see what other towns around us do. I mean, I just think we should, like Jennifer said, grab the ball, go with it, and let's make a decision. So 3 months, if March, April, May, that gives us
3 months of
quite a
time.
bit of time.
I'm giving you no argument. I'm just putting that out there for you, Teresa.
I just don't know if we give ourselves 6 months, I don't see us acting on it quickly.
Well,
But
I'd like to
I'm
act on
only
it
me,
sooner or
so,
later.
but I'd go for a 3 month, that I'm okay with, but what does the rest of the board think?
I'm new and I'm not quite sure what the implications would be versus doing nothing, and as far as setting a moratorium as versus just bugging along. Whereas you put the moratorium on there, then people feel like there's a date they have to reach. I feel like we might have more opportunity to plug along, because as it was said, if we do nothing, we're just it's not going to make a difference. We don't have a deadline set. So why should we set one for ourselves? Not saying that we should drag it, but try to do that public hearing type meeting like we talked about, getting the other agencies involved, like Brian said, and not set a specific moratorium. Just let's move on it and start making the discussions happen.
I think the one issue that you have though is that if somebody comes in with an application or you're in a circumstance where somebody's engaged in a use
Right
and
now,
you haven't addressed it, I think that it's best to have that protection of having that text amendment moratorium in place.
we have to do
You
that.
know, and I think doing it for 3 months is fine. Like, you know, if you hold a meeting and you hear, you know, that there's support for, you know, one micro cultivator, one retailer, you know, in a month's time, and you want to move forward and you direct, you know, you want regs drafted, and we come up with something, you know, within a couple of months and we get something before the commission, then you hold your public hearing on your text amendment and you move forward with it. I mean, yeah.
I don't understand that argument because we just said if somebody came through with something, imagine whatever the horror story that you're thinking of, and they came through with something, but the sale of marijuana is not permitted under our regs. Why are we behind the 8 ball if that happens? I don't understand.
Well, I mean, you just gave an example of the town of Hamden being challenged about a use. That's, again, I don't know what you're talking about. I didn't read any newspaper articles about it. Why would you put yourself in that position? To me, it just makes sense to not even have to deal with that, to be able to just point and say, you know, we have the moratorium in place for this short period of time. And, you know, we're addressing it and we're determining it. And I think it lets people who are interested know too. And just if you could, you know, if you're inclined again to do it, just if you could give me some guidance in terms of what you'd like to see as far as content of information. I know you've mentioned, you know, departments. I would like to know what you think about potentially having, again, some of these folks who've made inquiry and have expressed interest in opening establishment in North Haven. You know, would you like to hear from them in a meeting? It sounds like you want to hear from the public first, but maybe do you want to educate the public a little bit about the potential uses and maybe hear from those folks first? And then, you know, of course, have public comment as part of that meeting, maybe have another public session even after it, whatever, so you could get the information out to more people. Like, what are you thinking? What are you envisioning for how you want to proceed in terms of getting that public input? Because we could, you know, we could invite the people that have made inquiry, the people that are in the business that have made inquiry, and say, you know, we're going to have a meeting. Planning and zoning is going to have a meeting, and they'd like you to, they're going to allow you to come in and for 5 minutes talk about your business, tell them about your business and important things that you think planning and zoning needs to know to decide whether or not they want to allow the type of establishment you're running in the town of North Haven.
Jennifer, this
If
is
you want to do
Brian.
something like that.
Jennifer, this is Brian. This is kind of an outlier question, but
Yep.
now, if we, I'm not saying prohibition, but if we put a prohibition on this, and then if somebody came in, they got the required signatures for a referendum, and it went to vote. First of all, could it go to vote even after we put a prohibition on it? And would that be, you know, something that just would happen just because, you know, people voted on it and that's what they want? Is that something that could happen? Because that can direct this and narrow us down more towards the moratorium now, and what we're going to do and how we're going to take that 3 months so of moratorium and use our time wisely to get things together, the regs together, the input from people together to focus on this. Because if we said prohibition and then basically someone's just going to come in and just blow it out of the way, then I think we have to look harder at getting something in place that's going to direct people down the road just what exactly they can or cannot do based on the input we get from the people of the town and our input.
But Brian, I think you're pretty much on target there, because the moratorium is the only thing you can stop it right now, because there has been some very credible people that have inquired about opening up a shop and or some sort of shop or store or whatever you call it. But I mean, for real. And I mean, they just said, if you don't want us, we won't come. But the fact of the matter is, I mean, this is a little bit ago now that I heard about this, and so they just walked away from it at this point. I don't know where they are now, but the fact of the matter is, you know, you got to put something out there that's going to stop them now.
Okay,
To give us a
but
time
Vern, I have a
to take
question.
good look. Go ahead.
So I'm a little bit confused. I mean, a moratorium is one thing, but going for a referendum to prohibit it,
No, I didn't
that's
mean-
not in our purview.
Absolutely
And
not.
I mean, frankly, I don't want to see that happen because
No, I don't either.
But Teresa, I was saying that if we as a board said it's a prohibition, could somebody go in and initiate a referendum, petition for a referendum to then say, no, you may prohibit it, but we're going to have the people of North Haven vote because we want it. And that's what I'm saying is that based on the answer we get from that, it's going to say to us, well, we better get our stuff together here because we could be forced to do something either way, even after we say it's prohibited. That's just a question I have. I don't know if any action can be taken by the voters or the people in North Haven if we're prohibited by us, but I kind of think it could. And if it could, again, what I want to say, a moratorium would be a nice way to get our regulations together as far as it affects this, and all the input you were saying, and Jim and Vern.
I think you're right.
Yeah.
I think you're right. It'll give us 90 days to put our stuff together and a pretty good idea what we should be doing or not doing.
But Jim, what do you
with
think?
that? Jim Gilletti?
Yeah, I have to tell you, I'm not in favor of it. I'm just not, because we don't have a game plan in place. We don't,
No.
if you're telling me we're gonna do this month, this month, next month, and you want me to support it, that's fine. But otherwise, I'm not in favor, because if all we're gonna do is kick the can, that's what it sounds to me like we're doing, and I'm not interested in kicking the can.
No,
Jim,
Well,
Brian,
that's why I asked the
what-
question I did.
And that's
I
what
don't
worries
see
me.
the same risk that Jennifer sees. I just don't. If it's not allowed, I don't know where we're at risk right now. I think we should come up with regulations unequivocally. I do. And if you tell me you got some plan that we're going to do over the next 3 months, so that at the end of 2.5 months, I don't think there's any difference between today and 3 months from now. But if we're just putting in a stopgap, just for the sake of putting in a stopgap, which I think 40% of the towns did, I'm not in favor of it.
Well, Jim, you're right. And this is Brian, because we put in a stopgap 3 months down the road, we're in the same place we are tonight. And that's not going to make sense. So we've got
Okay.
to do something.
That
along
was the
way.
point. Yeah, that was the point of my asking, how do you want to proceed? You know,
So,
do you want to hear from particular departments? Do you want to hear from, do you want us, Alan and I, as, staff and council have received inquiries, opening it up, saying to the folks who are interested in opening establishment in North Haven, come on such and such a date and you have 5 minutes to address the commission regarding your business. I mean, I don't disagree with you. I mean, I think I want direction from you in terms of, if you want the moratorium, what you want to do during that time frame.
This is Brian here. I think we should have some action during the time frame. As far as what it is, public input is great. And work on some public input there. Come up with some regulations. Rod says he has been working on one in New Haven. Maybe we can take a look at that and get some input into what New Haven's done. I don't know how much will apply here. Hopefully not much will apply. Rod, I don't know if there was a lot of public input in New Haven for this, if you had that, but
Teresa,
just so we're acting within that 3 months, and we have sort of like a review each month of what's going on, because 3 months comes really quick, folks. And
okay.
yeah.
I mean,
thanks.
I have a plan, my plan would be, Jennifer, first, I'd like to set a meeting to listen to the people who want to come in with whatever establishment, within that range. I'd like to listen to them. And then I would like to go to an informational meeting with the public, have the public speak, have it be townwide, where we could present some of what we heard, we could be informed, listen to the public. And then between some of the rule regs that you have access to, that Rod has access to, I don't see why we couldn't make a decision in 3 months. I don't care if we have a moratorium. I don't think it matters one way or the other. I don't think we can get this done before, 3 months, but
Certainly can.
that would be my plan. Hear from the people who want to come here first. Hear from the public. I'm not all that hyped up about hearing from department heads, to be perfectly honest with you, because I think this is our purview. I don't think we need to hear from Board of Ed or police or fire. Other people may think differently, but I don't think so. So,
Why would you do that?
well, why would we do it? I guess because it's really a zoning issue. It's not a morality issue or anything like that. It's a zoning issue.
Yeah, well,
And it's been decriminalized,
Yeah.
and, I think that we need to treat it as a business. We don't need to treat it as a,
Alan, what do you think about that? Didn't you be on that with working with Jennifer?
Well, honestly, I'm really with Jim. We've been dealing with this, this issue in a very, very minor kind of peripheral way, where we've had people request, very nicely and politely, what are the town's regulations? And I say, well, we don't have a regulation. And just exactly as Jim said, our regs are permissive. So I said, something like this type of a use, you would just have to bring an application for an amendment and get the commission to act on that application. And then if they approve it, and I have no reason to believe they would or they would not, but
Right.
get them to bring an application, get the use written in the book, and then come in and apply under that regulation. But I agree with Jim. I mean, I understand what Jennifer's saying. Jennifer's the one who has to sort of stand up in court and defend it. But I've never really felt uncomfortable. I think part of the issue is, and this is just a few assumptions that I've made over the last couple of years, is that I think an applicant for a permit needs to have somewhat secured their zoning approval in order to go forward and finalize their dispensary or what have you. And the problem is that leaves a longer run for them because they have an extra step. And they very well know that there's going to be public comment, and it's going to be something that's going to be debated. It's not going to be a one and done meeting where it's going to go through quickly. And they tend to pass on North Haven because there's no particular reg that's put in place. Anyway, the long and short of that is, I totally agree with Teresa. I'm fascinated by what the public would say about this. I'm not worried about the a moratorium. If you want to put one in place, I'm fine with that. I'll tell you this, just in terms of logistics on a reg, you not only want to vet this, but you want to propose a regulation for it. The regulation either says it's permitted under some circumstance, or it's not permitted. But 3 months is not enough time to get public input and then put a reg in place. I mean, to put a reg in place, it's got to be in 45 days before the first public hearing. So again, that doesn't terrify me. I don't really care, but I think it's going to take longer to vet it and then get a reg in place than a lot of people are thinking.
Well, I think you're right. I think you're right.
But I'm not worried about it.
Bring them points up. You're absolutely correct. It will take a long time to get it in there.
Let me ask a general question. I mean, if our board is ultimately making this decision, is prohibition, which it seems that can be allowed under the statute, is prohibition somewhere that people are leaning towards going? I can tell you I'm not. Like, now, I would never say never, and I don't know what gets proposed. But is that, I'm not worried about the moratorium, but I think we should do a regulation, and I think we should allow it. And I'm more on Teresa's vein, similar to our regs for liquor stores. But if we're going to prohibit it, let's not kill ourselves. I mean, and I'm not telling people, we had an applicant last month try to tell us how you're going to vote. I'm not telling you how we're going to vote, but is there a sense that we would prohibit it in this town?
That never
So are
occurred
you
to me.
asking?
Jim, I mentioned the word prohibition. I was just asking a hypothetical that if that happened.
No,
you
I
know,
know where you were coming from, Brian.
Yeah, thanks.
But
But
could be in favor of prohibition and say, listen, we shouldn't sell marijuana in North Haven. You could be, it's a valid position. I just am saying, if that's what the majority of the board is, then we don't really have to go through this exercise unless I'm missing something.
Jim, just for one thing, and could we just clarify something here? There's retail marijuana sales. There are pharmacy or dispensary sales or medical sales, and then there's hybrid possibly. What are we saying to this now? Which one are we addressing? Are we addressing all of them? Because they have to be addressed differently. If it's medical versus retail, should be addressed differently. I mean, you can go to Walgreens and get some terrible things that'll kill you, right now. And, we got to break this down further. Which ones are we talking about here? And Jennifer, are there 3 different things we're talking about here? Or are we just talking?
So that's a question that I have. I think from Jim's comments, I've been assuming that he's talking about permitting retail sale of recreational. And that's what he's speaking of.
That's what I was talking about.
Okay.
Yeah, well,
So then there is a difference than what we're talking about now, as far as that medical sales. Are they a completely different beast here? I mean, it's still marijuana, it's.
So there is still the distinction in the law, but now, now you've got this additional, you've got this additional license of hybrid, which would sell both. So the question becomes, again, what types of cannabis establishments overall do you want to permit? And you've got 11, you've got 11 different licenses at play. And, I mean, it's about deciding, what zoning district, what area do you want to put a limit on, particular aspects of it. So as far as the location and otherwise.
So these are all things, Jennifer, that we're going to have to address in our regs to make it, there's a lot of wiggle room in regs sometimes, but you want to eliminate a lot of wiggle room when you put the regs together. So,
Yeah, I mean, I say all the time in meetings, when I'm talking about amending regulations, you want somebody who wants to engage in a particular use in your town to be able to understand from looking at your regs whether or not that use is allowed or not. So, am I in favor of doing something comprehensive so your interested parties here could understand what you're permitting? Of course.
Hours limitations is another consideration we'd be, taking up at some point.
But all of that, all of the things we're talking about right now are all things that we're not inventing the wheel here. So there's certainly existing regs in Connecticut, stuff that's already been worked on. I mean, obviously there's stuff from Massachusetts, So, well, it sounds like a lot. Once we get our hands on something that's already been done, if we want to tweak it, if we want to adopt it. Correct, Jennifer? I mean, we
Yes.
don't have to plod through everything. So I think we need to decide tonight, we're just gonna start going ahead. And I told you, what I think we should hear from the people who want to come to us and then hear from some of the public. That's all I think I need, but so that's what I'm gonna say would be my plan. So I'm
And
gonna be
then-
quiet now.
And Jennifer, I agree with Teresa there in that the length of the moratorium is basically up to you guys. You guys are the ones who are going to have to come up with the regs. And as Teresa said, there's a lot that already exists, a lot to get from the well. And I mean, what do you and Alan think is a fair time for the town to get all the regs together that are needed to be put in place?
I mean, in terms of samples, I have samples I could give to you.
Well, I'm just asking you. I'm
So,
asking you.
I
and
mean,
Alan.
as far as that's concerned, I mean, again, you've been having remote meetings. We can put, we could look and we could pick dates now. As far as, I don't think you need to go beyond 6 months. Again, I said that from the beginning. I think that's enough time. I don't really understand why so many towns have chosen to go beyond that, but maybe they have got a lot going on in terms of applications. I don't know. I think 6 months is enough time to hear from the establishments, to hear from the public. Again, one of your members has indicated that they don't think that there's a reason to hear from department heads, whatever. That's fine, of course. I mean, if you feel after a couple of meetings, you can decide the direction that you want to go in, and you can give us, guidance as far as that's concerned, and then put us to the task of drafting the thing. That's what we do.
I would really rather not try to come up with dates tonight. I have no problem with sitting down, with Jennifer and looking at the calendar tomorrow morning, and then sending out an email to the group and trying to hit some dates. But regardless, I think it would take probably a good 6 months to vet it out and to get something approved. But again, I'm not advocating for a moratorium, and it doesn't really matter to me. But to answer Brian's question, I think that's maybe where I would be. But I think we could come up pretty quickly with with some dates and meetings. And I'll mention something else. We have one application for next month. That is say for the March meeting, and that one application may be bumped off into April. So to me, that's a perfect date to start some sort of a public process here, and start hearing from people.
So that's March 7th. I know I
Yeah.
just sent the Zoom info out to
Yep.
Leslie today.
So whatever form that would take, and if the form is really a planning and zoning commission meeting, then the commissioner here firsthand, they could ask questions, on their own terms. And I like the idea of that.
That sounds good.
Yeah, I mean, I fully agree with using the March 7th meeting. We just have to structure it to do what? Is there a way to notify the public to come? Is that what we want to do? We want the public to come? We want those people that Jennifer's talking about that have expressed interest to come? And how do we make that happen? But I'm all for, if we only have one, I saw we only had one application. And whether it goes forward or not, that's not very much based on what we've had in the past. So we should absolutely use that meeting to address this. Maybe, well, I think we should just do one thing, because obviously all of this takes so much time.
I think that would be great if it's certainly, we have enough time, I think, to invite those interested people to come and speak to us. So that's how I would use that time, but
6 months moratorium is good. Is that good with you guys? Mark, how about you? 6 months good with you?
Well, like I said, I'm kind of new to the whole process, so I'm gonna just wave to you guys if that's, if you think this is the appropriate timeframe. You know, as far as Alan said, you know, getting the regulations together and actually putting something together, I mean, we still have a lot to do as far as input from other people, if that's what we want, and I believe that's the right direction to go.
So just in terms of, just something else to consider. So what format do you want in terms of the meetings for the public? I'm assuming March 7th, you know, we're going to be inviting people from out of state. You know, so we'll keep that fully remote, March 7th.
That would be good. It's still.
I would think, right?
Yep.
So the legislature will be acting because the fully remote and hybrid meeting format, remember that legislation only runs through April 30th. They came out with a report from the Intergovernmental Commission. It was very positive on the fully remote and the hybrid, but for people on occasion experiencing technical difficulties. So I think it's going to survive. So I would expect, you know, we're going to hear more about that. But as you move beyond April, that's something to take into consideration. Hopefully, maybe we'll hear something before your March meeting. I don't know.
Yeah, I mean, are we, just as an aside, are we going to go back in April? I mean, when do we make that decision? You know?
Tomorrow morning.
It seems like we've had some input from a couple of the commissioners now, you know, showing some reluctance to go back live. I don't know what it.
Well, I mean, at
We
some
can talk
point,
about it.
It's gonna be virtual, so.
well, how long are we gonna stay virtual though, Vern?
Well, I don't know, Teresa, how long are you gonna be wearing a mask?
Well, yeah, I know,
don't
but
agree
I'm,
with that either, but the fact of the matter is, right now, we're doing virtual meetings. I mean, we're gonna address the moratorium, we're gonna address the cannabis, we're gonna address the apartment, and we're gonna talk about changing the meeting.
Why don't we just put that on the agenda for March 7th to talk about that too? So but we're March 7th.
yeah, that's a good idea. That's kind of all I meant is when are we gonna talk about it? Okay, yeah, perfect.
I guess I just am wondering in terms of like when you go beyond hearing from the business owners and you're going to look into the public, are you going to do that in a public in a public physical meeting
Why
location?
are we not inviting the public on March 7th? I don't.
Oh, no, well, it's going to be a public meeting, of course. And the question was posed was how do we disseminate that? I mean, you know, we could, you know, post it on social media if you want to do that. You know, I'm happy to come up with something,
Yes.
you know, to notify folks in terms of a plan. You know, we're in the process of collecting responses for the housing plan survey. We could follow a similar path. You know, there could be an email sent out to board and commission members and town employees and, you know, flyers posted. I don't know to what extent do you want, you know, the information disseminated. What are your thoughts on that?
Well, you know, we just had I just did a meeting. I mean, the town meetings are now public. I mean, we did it in person at the town hall. So I guess if we were going to, I guess the question is, if we were going to have hear from people, I would prefer that. I mean, I guess my question is it going to be a town meeting or is it going to be a P&Z meeting?
It's going to be a P&Z meeting.
I would hope so.
Okay.
But
I mean, I would suggest, I'm throwing this out there. No, the first one I understand is a regular meeting. But I'm assuming the second one, if we had the public, like actually want to hear from the public, I would assume that might be a special one. I don't know. I'm assuming April might be busier than March. But
Well,
for that, my suggestion might be that we go to the high school for that.
Yes, I
So
agree
we're-
with that, just so people are more comfortable and could space out and so forth.
That's not high
That's a
school.
good idea. Yeah.
Yeah, because I don't think we can do it, in all honesty, I don't think we can hear from all the public on a Zoom. I don't think that's gonna work.
Well,
That's my feeling.
why don't we move it to, let's move this along to have the meeting on March 7th and see how it goes on the 7th. And also see, as Jennifer says, maybe she can brainstorm and put some, get the word out, and let's see who we get. Let's see if we get 2,000 people or if we get 12.
We're gonna get, let me just say this, that we're gonna get quite a few. Because
Yeah,
I've been
I
hearing.
agree
from-
with you. Yeah, I think
So-
you're right.
Right. And, well, I don't know. I mean, I guess, I know the rate is down at 3%. I agree, meeting on Friday,
Well,
this
you know,
next month for sure.
We could have them send a letter in as well, Teresa. Alan. Don't you suppose?
Well, yeah, they can. I think.
We could accept letters in respect to this as well. But
So-
Yeah, but I just don't think we're gonna get we're gonna get,
no,
I don't know.
I'm saying additional to Teresa.
Oh, yeah, yeah.
In that,
People who don't want to come to the meeting, yeah.
But okay, it sounds like we have a plan though. It sounds like we'll have the meeting on March 7th and we'll invite public comment
Right.
and of whatever type we get. And then we'll put the word out further if we need more pointed input. How's that?
Good enough. Is that good enough for you, Jim? Brian?
That sounds good to me. And I would just say this, the deference for the applicants, if this could come last, so we wouldn't have somebody waiting, for
Oh,
a
yeah.
long time. Okay,
Yeah, no, I agree, Brian.
thanks.
There's only one application as we sit there today.
Okay.
Right.
Jennifer?
Okay. I have direction. So anybody else have anything to say? Rod, do you want to weigh in? I can't see Rod.
I guess I just want to make sure that people know what they're coming to talk about. So whatever we announce, they'll have an idea, right?
Yeah, no, I'll make sure that it's clear. Yeah, I'll use some very pointed language in that regard. Yes,
Okay.
and we'll get that out soon. I'm
If we're
sorry.
gonna get the public, you gotta limit people to how long they can talk, and we can figure it
Right.
out.
Sure.
You
That's
can't let
sure.
people go
Yeah,
on
right
for
on the money.
20 minutes.
That's a good point.
3 minutes.
Yeah.
3 minutes, yeah.
3
Yeah,
minutes.
whatever, you pick whatever time you want, but
It's
do
all
it.
gonna go over.
do the timer, because we all know there's some people who get up there and they'll have a presentation that's gonna be 20 minutes long, and if you tell them up front, no,
Yep.
there is no 20
Yeah.
minutes. This is what you get.
Put it in there, Jen, when you put it out there,
You can work it out any way you want. huh?
they gotta put it together, they gotta squeeze it together tightly.
Okay.
Okay. Okay. Accessory apartments, we've talked about this legislation a bit. I'm going to move quickly through it. It's 10 of 9. So it's Public Act 21-29. I think I included a copy in the email that I sent to you. You're focusing on, in terms of the sections of the Public Act, section 1, 6, 7, and 10. These, public acts at this point have been codified into the respective statutes. But just in terms of an overview on it, and then I'll get into specifics. They require municipalities that zone under the Zoning Enabling Act, so Connecticut General Statute Section 8-2, to adopt or amend regulations to allow accessory dwelling units, ADUs, as of right on the same lot as single-family homes unless they follow the Act's opt-out process. The Act specifies that these units will not count toward a municipality's base housing stock calculation for purposes of the Affordable Housing Land Use Appeals Procedure 830G. It modifies the definition of ADU for purposes of the appeals procedure, and then specifies that the addition of an ADU on a lot does not make the sewage system a community sewage system. So definition of accessory apartment. Under the Act, an accessory apartment, also referred to as an accessory dwelling unit or ADU, is defined as a separate dwelling that, one, is located in the same lot as a principal dwelling unit of greater square footage, two, has cooking facilities, and three, complies with or is otherwise exempt from any applicable building code, fire code, and health and safety regulations. Definition of as of right is defined in the Act. It means able to be approved without requiring a public hearing, a variance, special permit, or special exception, or other discretionary zoning action other than a determination that a site plan conforms with applicable zoning regulations. There is a requirement of adoption of regulations in the Act. It requires that municipalities, again, that exercise powers under the Zoning Enabling Act of 8-2 to adopt regulations that allow one ADU as of right on each lot that contains a single family dwelling, and designate other areas where ADUs are allowed, unless a municipality opts out of the as of right provisions by January 1st of 2023. In terms of the other regulatory requirements that are in the Act, it does require, there's a whole bunch of them. It does require that the ADU regulations, number one, establish an as of right permit application and review process for the ADUs. The process has to require the zoning or Planning and Zoning Commission to decide within 65 days after an application, unless an applicant approves an extension or extensions up to 65 days total, or withdraws the application. Two, allows attached and detached ADUs and ADUs contained within the principal dwelling unit. Okay, so attached and detached, and then ADUs that are contained within the principal dwelling unit. Three, set a maximum net floor area for ADUs that is the lesser of A, at least 30% of the principal dwelling's net floor area, or B, 1,000 square feet. But regulations can allow a larger net floor area for ADUs. In terms of the other regulatory requirements, number 4, requires setbacks, lot size, and building frontage less than or equal to that which is required for the principal dwelling. Okay, so you can't have something that's different. It's got to be less than or equal to. Require lot coverage greater than or equal to that which is required for the principal dwelling. And provide for height, landscaping, and architectural design standards that do not exceed standards applied to single-family dwellings in the municipality. In terms of restrictions on regulations, so those were the requirements of regulations that I just went through. The restrictions on the regulations, ADU regulations passed by a municipality cannot, and again, this is if you don't opt out, cannot require a passageway between the ADU and principal dwelling. 2, an exterior door for an ADU, except as required by the applicable building or fire code. 3, more than one parking space for the ADU or fees in lieu of parking. 4, a familial, marital, or employment relationship between the principal dwelling unit's occupants and the ADU's occupants. 5, a minimum age for ADU occupants. 6, separate billing of utilities otherwise connected to or used by the principal dwelling unit. Or 7, periodic ADU permit renewal. So I mentioned earlier, in terms of the affordability requirement, municipalities cannot require as of right ADUs sharing a lot with a single family home to be preserved for lower income families. So they cannot require an affordability requirement. The Act does specify that ADUs built or permitted after January 1st, 2022, but that are not subject to deed restrictions that qualify them as affordable housing will not increase a municipality's base or market rate housing stock calculation. Okay, so as of right ADUs will not increase the amount of affordable housing that a municipality must have to obtain or maintain an exemption or moratorium from the affordable housing land use appeals procedure that's contained in 8-30J. There's a prohibition also on conditional approval that's requiring correction of a nonconformity or fire sprinklers. So under the Act, municipalities cannot condition an ADU approval on the correction of a non-conforming use structure or lot, and cannot require fire sprinklers unless they are also required in the principal dwelling or by the fire code. In terms of other provisions, the requirements of the Act do not supersede applicable building code requirements or other requirements where a well or private sewage system is being used, provided approval for any such accessory apartment must not be unreasonably withheld. Additionally, the Act prohibits municipalities, special districts, and sewer and water authorities from 1, considering an ADU to be a new residential use for the purposes of calculating connection fees or capacity charges for utilities, including water and sewer service, unless the ADU was constructed with a new single-family dwelling on the same lot, or 2, requiring the installation of a new or separate utility connection directly to an ADU or imposing a related connection fee or capacity charge. Laura's on, she and I have talked about this. We have some concerns about it. Laura, I don't know, when I'm done, maybe you want to weigh in. But under existing law, community sewer system is a sewer system service for at least 2 residences and separate structures that is not connected to a municipal sewer system or connected to it as a distinct and separate managed system of segment of the system. The Act specifies that a community storage system does not include a system serving only a principal dwelling and ADU located on the same lot. It does not prevent municipalities from prohibiting or limiting the use of ADUs for short-term rentals and vacation stays, and that's a big issue for some towns. In terms of the opt-out process, again, the opt-out, as I mentioned to you some months ago when I gave you just a quick overview on this, there has to be action by both the Planning and Zoning Commission as well as the legislative body. So in a town meeting form of government, that is the Board of Selectmen. And the process is the same within both, to hold a public hearing on the proposed opt-out subject to the standard notice and timeframes for such hearings, affirmatively decide by a 2/3 vote to opt out within the statutory time limit, generally, again, within 65 days of the hearing's completion, because remember, we're 65, 35, 65. State in the record the reasons for its decision, and then publish notice of the decision within 15 days in a newspaper that has substantial circulation in the municipality. So those 4 steps, again, they have to be taken if the commission is inclined to opt out of this legislation, then you must follow this very strict procedure that's given in the statute. As does the Board of Selectmen have to follow the same procedure. So just in terms of general topics that you should discuss regarding ADUs, and you know, these are things that I think are triggered by language in the Public Act. Owner occupancy, limitation on the number of occupants, limitation on minimum and or maximum of square footage, attached within footprint of existing structure and or detached. So whether or not to allow, again, attached within a footprint of existing structure and or detached, located within basements, attics, and or garages, consideration of that. Outside access, fronting on public street or not, whether to require access to front on public street or not. Internal doorway connection, architectural style, for example, exterior stairs, limitation on the number of bedrooms, requirements of kitchen, bath, utilities, parking spaces. In terms of the opt-out, I had mentioned earlier, as you know, I did go through this again. It's been a few months now. But there is a separate parking requirement now. It's on page 11 of the Public Act. That you cannot require more than one parking space for each studio or one bedroom dwelling unit, or more than 2 parking spaces for each dwelling unit with 2 or more bedrooms. Again, I'll say that again. You can't require more than 1 parking space for each studio or 1 bedroom dwelling unit, or more than 2 parking spaces for each dwelling unit with 2 or more bedrooms, unless you opt out in accordance with these same provisions that I just reviewed. And again, that opt-out process has to take place at the planning and zoning level, as well as the Board of Selectmen level. Just in terms of other considerations, whether or not you want to do a registration is something that is triggered too by the language. And then, of course, procedural matters, including how to approve. So,
Jennifer, can I jump in for a second?
I'm sorry?
I just wanted to ask a question before we move too far from it. Does that mean that there's a separate possibility to opt out just for parking?
Yes,
Okay.
there is. That's absolutely the way that I read it. They indicate only with that provision, and it's in subsection 9, Rod, at page 11 of the Act. They indicate unless the municipality opts out in accordance with the provisions of section 5 of this Act.
All right. Yeah, I'm looking
So
at
it's
that.
very specific to the parking.
Okay. Thanks.
So, again, as with cannabis, there's a lot of activity among the municipalities with regard to Public Act 21-29. You have a deadline of January 1st of 2023. If you don't opt out, then these are the parameters under which you have to operate what's contained in the Act. And I'll just say this, in terms of the conversation, I've seen most of the conversations in the minutes that I've reviewed of other towns are focused on the owner occupancy issue, as well as the minimum and or maximum of square footage. There are many towns that allow accessory apartments, and most of them do require owner occupancy and do have a maximum square footage that is under 1,000 square feet, generally.
Mm-hmm. So another sort of background on the New Haven process here, because New Haven enacted its own ordinance on that owner occupancy. I know that that was a large concern there, just because there are a lot of mega landlords in New Haven, and there was this concern that they would come in and start just doubling the amount of the structures on each property and renting it all out. And this was seen as a way to sort of control that, to make sure that anyone that's going to install one of these on their property will be living there, and so they'll care for it more, and it won't proliferate this sort of, the properties that could just get run into disrepair to try and maximize the profit out of it. It might be less of a concern in North Haven, but that was something that was a big concern there.
So again, I just want to make a comment too, Rod. I think this is an important, maybe you want to weigh in this as well, but this is an important, just to kind of segue into the last thing I wanted to talk to you about tonight, the prohibition on basically requiring affordability, right? So it's important just to note that there was also an amendment to 830G subsection K, which is the subsection of the affordable housing law that does define what is considered to be affordable. In K4 specifically, K4 and I just want to read that section to you. It says mobile manufactured homes located in mobile manufactured home parks are legally approved accessory apartments, which homes or apartments are subject to binding recorded deeds containing covenants or restrictions which require that such dwelling units be sold or rented at or below prices which will preserve the units as housing for which, for a period of not less than 10 years, persons and families pay 30% or less of income where such income is less than or equal to 80% of the median income. So it says, for the purposes of calculating the total number of dwelling units in a municipality, accessory apartments built or permitted after January 1st, 2022, but that are not described in subdivision 4 of this subsection shall not be counted towards such total number. So if you have legally approved accessory apartments that are subject to binding recorded deeds containing covenants and restrictions which require that the units be sold or rented at or below prices which will preserve the units as housing for which, for a period of not less than 10 years, persons and families pay 30% or less of income where such income is less than or equal to 80% of the median income, you still get credit for those. So don't be confused by that. It's something that I know a lot of people have been confused by. It's saying you can't require affordability, but that doesn't mean that if you fall into that category of having accessory apartments that are legally approved, that are subject to binding restrictive covenants in terms of the pricing for, again, a period of not less than 10 years, and you have that general, affordability requirement of being at 80% of, area median income, whether it be, whatever controls state or the regional area, then you can still get credit for those accessory units being affordable. So that's an important point because, obviously the discussion of accessory apartments is taking place in many towns with regard to the requirement of having to submit the affordable housing plan by June 1st. So, but again, this is something, all I can suggest to you, I can share with you this PowerPoint because, it kind of summarizes for you what you're accepting if you don't opt out. I think you just have to go over it and digest it and figure out, what your position is on it. Are you satisfied that, it's something that that you want to accept?
So let me ask you a very broad brush question. Who is advocating for this? I don't understand how this all comes to be. I'm not a big accessory use person, but why is this coming up now? What the legislature just said the town should think about allowing accessory uses? Is that what's happening?
So I think it's part of the push for affordable housing. I think that that's very clear when you look at, the act that it's contained in, advocates for more affordable housing advocated for this change.
I get it, but right at the very beginning of it, it says you can't require it to be affordable, right? I mean, so maybe it helps. It's a diversity of housing stock, but not necessarily as the state defines it affordable. So I just don't know. So the affordable housing lobby, for lack of a better word, and our diversity housing lobby is the one who's looking for this. Because I don't know who's advocating for it. And I guess that's ultimately what it's going to come down to for us. We got to decide, is this something that we want? And is this, Teresa, you and I have had this discussion for, is this the mini house thing on your back lot? Those tiny houses they build now? Can that be an accessory structure?
It can be. Yes.
I, for one, don't like those at all. But, I know we've had some discussions where Teresa doesn't agree with that. But I don't know why we would do, I can't figure out, I want somebody to make an argument someday, not tonight, because I'm getting tired too, of why we would do this.
God only knows, I'll tell you that. This is something.
If I can just mention something here. I've been doing what I do for 17 years, and it seems to me that one of the most closely and tightly guarded issues of regulations here in town is the jump between a 1-family and a 2-family. And I think that the direction of this is completely opposite of what the commission and the town has tried to pursue for, I don't know, 40 or 50 years. Jennifer, I think I saw that there is not a possibility of restricting the occupants of the accessory structure to a family relationship, marital, blood, anything with the other, the main house, so to speak, the primary residence.
Yes,
to
that
me-
is in there.
Yeah, and to me, that means you're going off and you're creating a possibility with all of the provisions to have effectively a 2-family dwelling, which I just want to be clear with the commission, it is not possible at this time. That's a big jump. That would be a really big jump.
It surely would. It would change the zoning in the whole town.
So I'm not saying to do it or not do it. I'm just saying it's in stark contrast to everything that the commission and has stood for and worked for, for years. But I'm
Also,
kind of with Jim. I'm not quite sure why this is there, and it doesn't seem. I understand what you're saying, Jennifer. It may be a seed in terms of affordable housing down the road, but I think it's an unusual kind of roundabout way of trying to accomplish it.
Also,
Anyway.
over time, Alan, houses get sold and residents change, and that's something to be concerned about over time also.
Right, but I mean, we have no affordable regulation, which, some of this discussion is aimed directly at towns like us who have no affordable regulation, who make no real effort to make affordable housing. And that is why this came up. And there are some people, one that I know very well, who, has a daughter who can't afford to live here really, but wants to put something up on their lot so the daughter can live there. I'm not saying it's right or wrong, but that's what it's addressing right now.
That's what I was thinking about too, is we're seeing these pretty dramatic increases, I think, in this generation of people still living with their families and their parents because they can't afford a house on their own. And something I've seen in New Haven too, when I was mentioning before about these mega landlords coming in, buying up property. I think it's actually keeping, the effect of it is, and it's just a nationwide thing. It's inflating house prices to the point that it's impeding people from buying a first house. And so I think that I see that as it's part of addressing that too, is allowing people another option for people when there's, when they don't
Right.
can't afford a house of their own and everyone's moving back in with the parents.
The difficulty I see with that analysis, even with Teresa's analysis, the statute itself, you just told me, said you can't restrict it to be family members. So that means you could put it up that little house to be family members, and once little Susie moves out because, whatever reason, they can rent it to anybody.
That is true, but that's also part of, from what I've read, part of why they want to do that. So people who are living there, particularly some older people, could rent it and make a little bit of an income,
But
and they can stay in their homes. I'm
Again-
not saying it's right or wrong. I'm just
I
telling
get
you
it.
the
So the statute essentially advocates for multifamily dwellings in our residential areas. That's really what it comes down to, is what we're
Yes,
at.
Exactly.
yes,
what-
because
yeah.
so many suburbs have fought against it, and we as a board, and I do blame us, have not addressed affordable housing. So this is a way to say, hey,
I don't see that argument. But anyway, so what do we do now?
I don't know.
Can I just point
Jennifer.
out one more thing real quick? It is possible to have an in-law setup in your home right now. And the way that's interpreted by staff at this point is if you want to have a second kitchen in your house, you're welcome to do that. But your house has to be set up in such a way, you saw the language about no passageway may be required. The town currently requires that your house be laid out in a manner that you live as a single family. So it has to be contiguous. You can't walk across the backyard to get to your addition. You can't go through an unheated space. You have to have, it's a single family dwelling. That's what you have, and that's permittable. So right now, we could give you a permit to put an in-law setup, and I'm being very careful we don't use the word apartment here. We say an in-law setup, you can do it. You can add on to your house. If you want, you know, perhaps, you know, a son or a daughter you want to add on to your house and have them live with you, you can do that currently.
Yeah.
But now, let me say this to you. That is only your house is conducive to that. You can't do that everywhere, because what that passageway that we just talked about is the very, very small word, but it's a big part of this. It passageway.
It's a different issue, but a bunch of those, Alan, get used illegally later on. A relative moves in.
Yep.
Always a relative moving in. Relatives move out and they rent it to other people. I mean, that's happening. We all know it happens. It's not supposed to happen, but it happens.
And in-laws pass away.
Well, exactly. And now you've got the space. What do you do with that space? Well, I know what they do with it. So, but anyway, this is a different issue right now. This one is saying, do we want to flat out say we're allowing, you know, these accessory use buildings for complete strangers? It's not, we can't, I found, Rod, interesting, you said, I thought New Haven is limiting it to family, but this statute says you can't.
Yeah, no, it's not family, it's to owner occupant. So that you have to live on the property. You can't buy a property, not live there. That's the restriction in New Haven. You know what I mean? Like you have to live on the property, but you don't have to rent out to a family member. It can be anywhere in New
You
Haven.
can live there and rent to anybody.
I got it. So it can't be an absentee landlord.
Right.
Exactly.
Got it.
So the city is opting out then?
Well, it's a special act town, so it's not, it created its own ordinance and
Oh.
took the position that it doesn't have to abide by this one.
Yeah.
But it's largely in line with, you know, the requirements of this.
Okay, any other questions? Again, I think this is something, listen, January 1st will be upon us before you know it. We're already at the end of February. I do encourage you to decide, you know, which direction you want to go on this, you know, certainly before the end of the summer. So that way, if you are opting out, that you give the Board of Selectmen time to hold the necessary public hearing before their board as well. And go through the procedure. So, you know, I think we should continue to talk about this. Obviously, we've got a plan for your March 7th meeting, but maybe pick it up again in April. I think it would be a good idea to revisit again then. And
Okay.
in the meantime, you know, I'll get the PowerPoint because I think it gives you a good summary. I'll get the PowerPoint to you so that you could look at it. Okay.
Very good.
In terms of the last item on your agenda, I was going to give you a status update with regard to the town's affordable housing plan. I have discussed with you before, and you're aware that the Board of Selectmen did appoint an affordable housing plan advisory committee. That committee is 10 members strong, and one of the members is Rod. He's the vice chair of the committee, so he's been diligently participating in the committee meetings. You know, it's become very apparent, you know, that there are housing needs that need to be addressed. The committee has been moving through the process. They've been gathering information. They've held some community outreach sessions. They've had conversation with developer. They've had a conversation with some folks who work in workforce training and job training. They heard from the Director of Financial Stability of United Way, who gave a staggering number of folks in need of affordable housing in the Greater New Haven area of 134,000 people. They also heard from Kim DiMiola from the App Foundation, somebody from Gateway who works with persons with disabilities. So it's been a great process, I think, for the participants who have great professional experience and are all North Haven residents. They're great volunteers. It's been a great learning process. Rod, I don't know if you have anything you want to add before I move on to sort of exactly where we are at this point. I think he's frozen.
Sorry, I had to switch my internet. Can you hear me?
Yes.
Jen, you summed it up pretty well. I feel like we could keep learning about this forever. You know, the more we go through these meetings, the less I feel I know, and it's been a little bit frustrating because to me, North Haven. This just feels like a difficult task in North Haven because it's the financial challenges, as I understand it, to build affordable housing, and then the typical footprint or the ideal place to put these is one where people have access to shopping that they can walk to, public transportation, all these things. That's difficult to fit into our town, and so it's somewhat of a daunting task to figure out what the best approach is.
So just with regard to that, yes, by and large, the committee has heard, it's not just about addressing the housing need, but there are other barriers, and that's a very important point. There are barriers in terms of transportation, high transportation need when folks are in need of affordable housing. There's a very strong childcare support need as well as a healthcare access issue, having access to suitable providers and such. So yes, location. Somebody did come in who has been a great volunteer with Habitat for Humanity for a number of years. He talked about the Habitat model. He told us that he has talked to the first selectman about bringing the Habitat model to North Haven and how difficult it is because the price of available land in North Haven and the fact that the town in terms of the rate of foreclosures and so on and so forth, there's not that availability, that access to land that there is in other communities like Hamden, and he said they've also built some in Wallingford as well. They have a great number just in terms of their model, just to inform you. So they've built 140 homes in Greater New Haven, and I did not realize this. I've volunteered for Habitat. They give their families who go through a heavy vetting process, because what they're doing is they're providing single family housing for the working poor. they give them a 25-year no interest loan. So they construct their houses for $150,000 and they sell them to their families for $96,000. So they've got certain businesses that have supported them through donations and whatnot through the years that have enabled them to do this. So it was very interesting to hear from him and what they offer too. So, but in terms of the plan itself, so here's where we are. I circulated to you the existing conditions report that was prepared by the Council of Governments, and then the consultant that was hired by the Council of Governments to assist the participating municipalities, of which there are 13 of the 15 that are the member municipalities of the COG. Both Bethany and Branford opted not to participate in the process. They're doing their own thing. They have their own consultant. But RKG has drafted an existing conditions report. It reflects the demographic details that were shared with the committee in a separate report. I think that I gave you also a copy of that. I think what's most important to pay attention to, just in terms of the demographics, obviously, there's population demographics, there's housing tenure demographics, there's education related, and of course, diversity related. But there is the affordability gap analysis is I think it begins at page 27 of the existing conditions report. So, pay attention in terms of your review with regard to that. It indicates that in North Haven, about 47.9% of the renter households and 14.1% of the owner households earn less than 50% of the area median income. So that total is 1,841 households. So these households often experience housing instability, may rely on housing assistance, and are typically spending more on housing as a percentage of their overall income. So in terms of that cost burden, the numbers are just by and large, they are shocking for Connecticut overall. The amount of people in Connecticut that are spending more than 30% of their typical wages on housing is, I think David Fink, I don't know if everybody remembers David Fink. I think he's appeared before your commission. He used to be, I think he was policy director for what was the organization? I can't even recall. It's going back so many years now, but Partnership for Stronger Communities, right? David gave a statistic of 128,000 people in Connecticut spend more than 30% of their typical wages on housing. It's so significant, right? So another point, just with regard again to the gap analysis, the supply and demand gap for ownership housing units in North Haven. It says there are more potential buyers in higher income brackets than there are housing units that match their price points for households earning at or below 50% of AMI. So area median income. There is a shortage of 863 housing units in the conventional lending scenario and a shortage of 741 units in the FHA lending scenario. So for units valued between 50 and 100% of AMI, there is a net surplus of 1,440 units in the FHA scenario and 2,673 units in conventional lending scenario, indicating higher income households are likely buying down in North Haven's market since overall vacancy for homeowner units is relatively healthy. So that's, there's so much to consider in terms of what the data shows. So right now, in terms of, I don't know if any of you took the regional survey that was put out in the fall by Scrog. North Haven had very limited response to that. There were only 115 respondents. The committee decided that it would issue its own supplemental housing plan survey. That is currently active. I don't know if any of you realize that. You should have received an email with regard to that. I do encourage you to take it. It asks, one of the deficits that the committee saw with regard to the SCROG survey was that it didn't ask about future housing plans. So it didn't ask, when do you plan to move on from your current housing circumstance, right? And specifically because this plan that is currently being drafted is to be for 2022 to the middle of 2027. It's a 5-year plan. So just to get a sense, who's going to be looking to be moving within that period of time, or they're looking to move to a smaller or larger home, what type of housing type, do they want to rent or own, do they plan to stay in North Haven? So those are some of the questions that are being asked, that information that we're looking to capture. We already have a considerable amount more in terms of collected responses than the SCROG survey. We also have a much higher completion rate than the SCROG survey by a good 30 percentage points. So the survey seems to be having the desired effect that the committee intended in terms of gathering some more good information. So as far as the plan itself, the content of the plan, one of the things that I think would serve you well is to look at the Planning for Affordability in Connecticut, the Affordable Housing Plan and Process Guidebook that was published by the Department of Housing and the Regional Plan Association. It outlines the methodology for the content of the municipal affordable housing plans. The content is to include a community value statement. The history of affordable housing in the town of North Haven will be included. The housing needs assessment piece that will contain, again, this existing conditions content and the information now to learned from this new survey that's being conducted. There's a land use and zoning assessment. The point of the land use and zoning assessment is to actually identify available locations in town for affordable housing. So that's another important piece. We haven't received anything from them with regard to that. So as soon as we do receive that, that will be distributed to the Planning and Zoning Commission as well as the committee. And then the plan goals and strategies for reaching those goals or actions as is defined in the methodology. So you have been invited. I did, and all of you, I think all of you indicated that you are available to attend the committee meeting, which is scheduled for the 22nd with SCROG and RKG. That meeting is going to be to talk about the identification of the plan principles, the value statement, as well as the goals of the plan. So I am going to be, after there's a committee meeting tomorrow night. After the committee meeting tomorrow night, I'm going to be distributing to you some sample plans that have some statements of values and goals. I know, obviously, and I have shared with the committee the excerpts with regard to affordable housing that are contained in the last plan of conservation and development that your commission passed. So they have seen that. Again, those objectives of the POCD with regard to affordable housing. So, but that's the plan for the 22nd. And again, in preparation for that, I do suggest that you take a look at the guidebook. It is pretty short. It's a great read with regard to just what the content should be. It does have some information on what a couple of other towns have in their plan, and that affordability gap analysis in the existing conditions, again, towards the end of the plan. The town of North Haven has been grouped with Hamden, with Wallingford, and with Meriden. They've grouped the participating member municipalities. I see some sort of grimaces over that from the commission. And that doesn't mean that our plan is going to be like theirs. They're drafting individual plans for each town. And obviously, you know, they're getting input from the committee. The plan is going to go to the Board of Selectmen. It's going to have a public hearing. The Board of Selectmen is going to be able to make whatever changes they deem necessary, also coming out of that public hearing. But this is why we have a very healthy committee. You know, we have a member of the Planning and Zoning Commission. We have, you know, a member of the Board of Ed. We have somebody with workforce and job training experience. We have somebody who works for the Chamber of Commerce. We have somebody that works for Quinnipiac. We have, you know, we have a lot of great, vibrant volunteers who are making great comments about content and whatnot. So, you know, we're moving through this process, but this is our opportunity again to meet with, and I did not know this, but this is sort of the one opportunity to actually meet with the consultant, because the next meeting will be in that grouping. Again, with representatives of Hamden and Meriden and Wallingford, to talk about final strategies and content. But you know, this is the opportunity for everybody to get together, for you to share as Planning and Zoning Commission members, and ultimately, you know, if something, and you know, Teresa made the good point that the town of North Haven does not have an affordable housing rec. If you know, there are regulatory advancements that need to be made, you know, there's the opportunity, and certainly if the commission want to have another combined meeting, we could do another one before the draft goes to the Board of Selectmen. We have time to do that in March, you know, it's important, I think, that your commission be involved at this point, because ultimately you are the authority that determines whether or not there will be any text amendments that will be made in order to address the goals and the strategies. So I want, you know, for you to feel very comfortable, but that there's recognition of that, certainly by the committee, and of course the Board of Selectmen knows that as well. So, but this is the recommended process. You know, the recommended process when you read the guidebook is to create this local affordable housing committee that participates in the process that we're going through. So that's what's been done.
And Jennifer, I only grimaced only because it
You
makes
weren't
no
the only one.
sense to group us with 3 places that are totally we're not like, as opposed to putting us with something like East Haven or Brantford. So that's why I grimaced. That's all. And I'm tired, so okay.
Good night.
I tried to get through that quickly.
You did a good
Yes, you
job.
did. You certainly did that.
So does anybody have any questions? Just with regard to the 22nd, I do expect the SCROG and RKG representatives. It's Eugene Lifshitz from SCROG and then Eric Halverson from RKG. I do anticipate that they are going to be participating remotely, but we do have the library, because there are some members of the committee that do like to come in person. And then, you know, we have had some members of the public that have come in person, but more have participated online. So we are getting some public comment that has been very good public comment as well. And there are a lot of comments in the survey. So when the survey results are finalized, you're going to see all that too.
Jennifer, this is Brian. Did I
Really
understand
good.
you to
Is there
say
anything
that,
else?
Jennifer, this is Brian. Did I understand you to say that some of the people with more means are buying down in North Haven, taking some of the houses?
So that's a concern. Okay, so really, when you think about this, and I said this at the beginning of the committee, to the committee as well, when you think about what needs to happen, and you guys know this because you've been doing it with the POCD drafting for years now, you've got to look at housing holistically, because if you don't have, if somebody can afford luxury housing and they're not making that step up, then they're not freeing up what they have for the folks that could afford what they have, right? So it's not just looking at affordable, it's looking at, you know, when we talk about diversity of housing stock, Rich Lepresti has been very active in these meetings as well, you know, made the point of, you know, we need more mid-income housing as well. So it's not just about, you know, needing more affordable. But that certainly is, yes, what they're saying is reflected in the data that they have.
Yeah,
That is an issue.
that's what I saw when I was reading through that, and you just
Mhm.
said that. So it's at both ends and it's out throughout. For both low and throughout, that there's some people are buying houses that could be bought by people with more modest means.
Yes.
Well, I mean, Brian, it's, you know, the seniors, the people that I know who don't have a place to go, and I'm saying maybe, you know, the 70-year-olds who are looking for a place to go, but they aren't low income and they don't have 350,000, they have a house worth like 250. There's no place for them to go. So they're staying in that house, not freeing it up for a first-time home buyer.
Yeah, that's what I was getting at. That was asking.
Yeah.
Yeah.
And there are a lot of issues with aging in place. There are a lot of issues too with just the age of housing in North Haven. I mean, take a look at those statistics, because then you're talking about, you know, the need for houses to be rehabilitated. You know, for people in need of affordable housing too. You know, there's failure of systems and so on and so forth. So, you know, that there just is, there's a lot that has to be done. And like Rod said, it's overwhelming when you really look at the whole thing from different angles. It just is, it's almost like, where do you even begin? But the answer is not to charge towards it. And I think that that's the point of this whole thing, right? Is the law's been in place for a long time. And we don't want, you know, we don't want a court, for example, you know, if you're not exempt from the appeals process, you don't want a court deciding. You know, you want to decide as a community, you know, what is a good quality of life too for the people that are living in the community and moving into your community and so on and so forth. So I think there's a recognition of that. You know, and like you said earlier, with even the cannabis legislation, you know, we're not reinventing the wheel here. We know that there are communities that are out there that have done it well, that have regulations in place, that have you know, engaged in certain strategies and so forth to grow their affordable base. Interestingly enough, though, the number of exempt municipalities has kind of stayed around the same number for all the years that I've been practicing law. You know, it hovers around, because as more housing gets built, your affordable number drops, right? So it's been, for the longest time, it seems like the same 30, 31 municipalities that have been exempt from the appeals procedure. And that's a whole, and look, we don't know where this is going. We don't know, you know, there've been advocates for the changing of the law. We don't know what's going to happen going forward. We just know what our task is right at this moment.
Good enough. Good, Jen. Has anybody got any more questions for Jennifer? Any have any questions for Jen? Brian?
No, Vern, thank you.
No? Alan? Teresa? Jim?
I
Rod?
have more questions, but I'm really running out of juice.
I got you. I understand. Well, trying to close it out a little bit.
You were talking about those people that are turning 70. That's not too far from me. And Vern's got that way in his back mirror, so it's getting late.
It's getting late. It's getting late. But Jennifer?
I don't have anything else to say. We spent a lot of time on cannabis, which I expected.
Thank you very much, Jennifer. Okay, with nothing else to say, can I get a motion to close the meeting?
Make a motion to close the meeting.
I have a second.
I'll second.
Okay.
All in favor?
Aye.
Aye.
Thank you all. Jennifer, thank you very much.
9:45
Thank you,
PM.
Jennifer.
Thanks so much, you guys. Take care.
Have a good night, everybody.
See you next
Good night.
week.
The preceding program is brought to you in part through a grant from the town of North Haven. Watch town meetings or other videos on demand at nhtv.com.